Well, first of all, I want to thank Macquarie University and Law School for this extraordinary occasion. I think it's conventional these days for someone in my position to say they feel humble, but in fact I'm enormously chuffed by this. and all the more so because it's such a surprise. I want to thank all of you for being here, and above all, of course, I want to thank Michael for a typically illuminating, entertaining, wonderful performance. He's been a wonderful student, a wonderful colleague, a wonderful judge, and a wonderful friend. And it's my moment now to pay tribute to him. Natalie mentioned, and Michael also mentioned, that the year in which I taught Michael, the very first year I taught, was extraordinarily rich in judicial talent. Michael mentioned himself and Murray Gleeson, and I've always said they were two of the best students I ever taught. He also mentioned David Hodgson, Brian Tamblin, Jane Matthews, but there were more. I counted up 7 future judges in that one class. It must have been, I doubt if there'd been any other law school class so full of judicial talent. It also included at least 2 law professors, John Peden and Geoffrey de Q. Walker. Peden, of course, later became one of the foundation professors of law here at Macquarie. So it was really a quite extraordinary class. And I was very lucky to have such a wonderful introduction to teaching. My subject in those days was jurisprudence. It was moving to me to recall, as Michael spoke, some of that time with Julius Stone. It was, as always, as all times were, it was a tumultuous time. I remember an occasion when I stormed into Stone's office, tore up the galleys of his book and threw them at him. But it was family, and, and it was a very wonderful relationship. And I'm very proud to think that I might have carried on some of that tradition. Because it was jurisprudence, my early writing was sometimes on justice, sometimes on the judicial process. When I went overseas, I found that I could write wonderful, scathing, scintillating criticisms of the Supreme Court of the United States or the Supreme Court of India. But when I came back to Australia and tried to do it about the High Court, I found I couldn't do it. I was too steeped in the inhibitions of respect and deference. It was, after all, I had been a student in the years when Sir Owen Dixon was Chief Justice, and we had all been brought up to revere and admire him. Michael talks about the power of 4. It was only years later that I realised that when Sir Owen Dixon was Chief Justice, 2 other judges, Fulligo and Kitto, would always agree with him, so that when the court sat as a court of 5, Dixon always made sure that all 3 of those were there, and when the court sat as a court of 3, he always made sure that at least 2 of the 3 were there. So it's partly not surprising that Dixon's influence was so extensive. Nevertheless, our habits of deference, respect, were very deeply ingrained. I remember around that time Lester Mears, QC, getting up in court and saying, "With the very greatest respect, I would respectfully submit, if Your Honour would permit me to say so, that Your Honour is wrong." And it was in order to sneak past that inhibition of deference towards the High Court that I escaped into jurimetrics, which did indeed get me past those natural inhibitions about speaking frankly about what actually happens in the judicial process. One of the papers that I gave using the geometrics reports was in a conference in 1976 when my paper was commented on by Michael Kirby. Michael, at that stage, remarked that my use of geometrics was interesting but unsatisfying. And so I was rather pleased tonight to hear that he perhaps attaches more weight to it now than he did then. On the other hand, someone who was tremendously enthusiastic about my geometric work during the 1970s was Lionel Murphy. Murphy had been a scientist before he was a lawyer. It was the scientific aspirations of geometrics that particularly enthused and excited him. He took to ringing me up from the High Court and saying, "This'll throw your figures out, I've just agreed with Harry Gibbs." and the geometric work did indeed get me past those barriers, because by 1980 I was able to talk about the High Court, quite frankly, by quoting T.S. Eliot and comparing the High Court to J. Alfred Prufrock. Politic, cautious and meticulous, full of high sentence but a bit obtuse, at times indeed almost ridiculous. Actually, that was only half of what I said. In 1980, the Queen had come to Australia to open the new High Court building, and in her opening speech, she said, "In these times of social change and tensions in the world, great are the demands upon the courts and the challenges to them in reconciling competing interests and in accommodating traditional rules to new circumstances are great." And my theme was, and I suppose still is, that these are two models that judges have to choose between: the response to social change that the Queen spoke about, or the cautious, ridiculous obtuseness of J. Alfred Prufrock. And I suppose, in a sense, as you watch the judicial process over the years, you can see it moving between those two poles. But certainly what I've always sought to do was to encourage the Queen's version rather than the T.S. Eliot version. Michael told us perhaps more than he should about some of the errors and exceptions in my career, including some of the things at the early days of New South Wales. It's true that I was committed for trial on obscenity charges, 8 charges, 4 of which I did and 4 that I didn't do. I was indeed, when Wendy Bacon came into court to be sentenced, I was outside the court selling copies of the paper of which she'd been convicted. But other friends of Wendy's had produced an obscene broadsheet attacking the trial judge, came up to me and said, "Here, you might be interested in this." I said, "Thanks," and put it under my arm. So I was charged with 4 charges relating to the paper I was in fact selling, and 4 relating to the paper that I just happened to have under my arm. We were committed for trial. My barrister at the committal proceedings was Mary Gaudron. Had we gone to trial, the leader would have been Trevor Martin, who also had a very close association with this university. But after we'd been committed for trial, Mary wrote to the Attorney-General and suggested that he should file a nolle prosequi, a no bill, on the 4 charges we didn't do. And after about a year, they did that. And then Mary wrote again and said, "Well, now you might as well give us a no bill on the 4 charges we did do." And after about another year, they did that too. So we never actually went to trial. While I'm responding to Michael, I should say something about the letter C. C stands for Charles Blackshield, which was my father's name. It also stands for Constance Blackshield, which was my mother's name. So in saying that I was the son of C. Blackshield, I wasn't being sexist, let alone misogynist. I was simply being economical. C also stands for Constantine. My master solicitor was Constantine Don Service. He was the first Greek solicitor in Sydney and had changed his name from Con Servatopoulos. C also stands for Carl's Coffee Shop, and when Michael described us as articled clerks scurrying from the office to the lectures, he left out the intervening time, much of which was spent in Carl's Coffee Shop. This was before the Catalina opened in the ground floor of what later became Sydney Law School. Well, by the time of that 1980 speech, as Michael said, I had moved to La Trobe. It was true that I was disillusioned with New South Wales, or rather that I was disillusioned with teaching law students. I wanted to do something different. And the Department of Legal Studies, and I was Professor of Legal Studies, was not a law school. We were not teaching law students. We were part of a school of social sciences, along with a Department of Politics and a Department of Sociology. And it was that wonderful opportunity for exciting interdisciplinary research that drew me to La Trobe. But once I got there, I found that in that wonderful, exciting interdisciplinary environment, somebody had to be teaching the students some law. And I realised that it had better be me. And it was then that I became a lawyer. It was also while I was at La Trobe that, as Michael mentioned, we went through the terrible ordeal of the Lionel Murphy affair, the wave after wave of incredibly wild allegations against Lionel that ultimately led to his death. I think it's fair to say that I was one of Murphy's strongest defenders. Michael Kirby was another, and it certainly did Michael credit. It was perhaps more difficult for him than it was for me, but we both did what we could. Because I was in Melbourne at the time, I was often quoted in the Melbourne Age, but the Age had a vested interest in the campaign against Murphy because it was their publication of the so-called Age tapes that started the whole thing. And so the Age regularly would quote what I had said, but would preface it by saying that I was a personal friend of Lionel Murphy in order to discredit what I was about to say. The irony of that was that when the Murphy affair began, I was not a personal friend of Lionel Murphy, but by the end of the affair, I was. Other commentators at the time, other media at the time, in quoting what I said about the Murphy affair, referred to me as a constitutional lawyer. So I decided I'd better become one. And it was at this stage that I started putting together the teaching materials that ultimately became the basis for Blackshield and Williams. So in a sense, I was a late bloomer. The Pearce report, as Michael said, came in 1987. It was a report by 3 law professors, one from the University of New South Wales, one from Monash, one from the ANU. And basically it said that Australia had 3 good law schools, the University of New South Wales, Monash and the ANU, and all the others were hopeless. But it was as to Macquarie that it was really devastating. It said the teaching at Macquarie was among the best in the country, the level of student satisfaction was the highest in the country, but because of the intense infighting amongst members of staff, the law school should be closed. Now, I knew something about Macquarie, and I knew there were problems, but I knew it shouldn't be closed. So I sat down that night and wrote an application to come here, and a year later there I was. And as Michael says, he as Chancellor and I as sometime Dean of the Law School went through some turbulent times together. It was in order to lighten the atmosphere and raise student morale a bit that I first persuaded the Student Law Society to put on a dinner to commemorate the 70th anniversary of the engineers case. Michael Kirby, as Chancellor, presided at that dinner. Garfield Barwick spoke and moved a toast to the engineers case. Mary Godwin also spoke, and I sang a song. The occasion was written up at length in the Australian Law Journal. I suspect that Michael Kirby wrote the report. And it said that my song was received with a mixture of amusement and amazement. Amusement and astonishment. Well, that was all very well, but I found that from then on, every year, the students expected to have another dinner, and I was expected to sing another song. Michael was a guest at several of those dinners and so had to endure several of those songs, and he knows very well that some of them were better than others. But since he has expressed a fondness for the Melbourne Corporation song, I'd better oblige. The Melbourne Corporation case was decided in 1947. Basically, the Chifley government had passed a law requiring all state government authorities to do their banking with the Commonwealth Bank. The Melbourne Corporation challenged that law, and the High Court held that it was invalid, partly because the Commonwealth cannot discriminate against the states. It cannot make a special law about the states that doesn't apply to anybody else. And also because the Commonwealth cannot poke its nose too deeply into the internal workings of state government. So that's the Melbourne Corporation principle. And there are other cases in which it has been applied, but because it's not based on anything written in the constitutional text, it is said to be implied in the very existence of a federal system. It's a bit vague as to what exactly the principle is, and there have been many cases in which the High Court will say, that's a very important principle, but of course it doesn't apply in this case. So I tried to put all that into a song. Basic to every federation is Melbourne Corporation, and what that case dictates. Simply, you must protect the states against discrimination. Also, there must be no appearance of too much interference in vital state concerns, even if such a doctrine turns on verbal incoherence. If you impair core state functions more than is due, there'll be High Court injunctions, but only on one view. For all this is just an implication, there is no limitation that's textually set. That's why it's never safe to bet on Melbourne Corporation. Now, the Melbourne Corporation dinner was on the 50th anniversary of that case in 1997, And a year later, in 1998, we had the 10th anniversary of Cole and Whitfield. Now, Cole and Whitfield was a case about Section 92 of the Constitution, which says that trade, commerce and intercourse among the states shall be absolutely free. And through much of the 20th century, that had been the most litigated section of the Constitution. It had early on been given an extraordinarily wide meaning, much of it through litigation involving Mr. Frederick Alexander James, who grew dried fruits in South Australia, and who successfully challenged state and Commonwealth restrictions on the sale of dried fruits. In an endless series of cases, James and the Commonwealth, James and Cowan, James and South Australia. And in those early cases, some of them, Sir Owen Dixon dissented, but as time went on, Dixon developed his own theory of Section 92, which in the 1950s spread the effect of it even wider. Many of those 1950s cases involved Sir Garfield Barwick at the bar, and indeed it was largely through the Section 92 cases that Barwick earned his reputation as the foremost lawyer in Australia. When he became Chief Justice, he tried to push Section 92 even further than Dixon had done, and it was at this stage that some of the other judges began to react. People like Mason and Stephen began to move away from the orthodox view of Section 92 in reaction to Barwick, who I think was really trying to push it too far. In 1987, Tony Mason became Chief Justice, and Cole and Whitfield was one of the first landmarks of the so-called Mason Court, in which all the previous law on Section 92 was torn up, and we went back to a much narrower interpretation. The case arose in Tasmania as a result of a prosecution for selling undersized crayfish. The defence was that the crayfish had been imported from South Australia, and that although they were indeed too small to be sold in Tasmania, they were perfectly legal in South Australia, and therefore the prosecution was an infringement of the freedom of interstate trade. On the new version of Section 92, that argument failed. The reason why the crayfish were too small was significant. It was explained to the court that the water in Tasmania is so cold that crayfish take a very long time to become sexually active, and therefore they have to be allowed a few more years to mature and to breed in order to maintain the breeding stock. And that's why it's illegal to catch them too small, in other words, too young. Well, I tried to put all of that into a song. Absolute freedom of interstate trade, that's how the Oz Federation was made. No border customs and no barricade, that's why the trader was a champ. Interstate traders were totally free from laws that were binding on you and on me. No controlled prices and no licence fee, that's why the trader was a champ. They loved the free, fresh, federal air, full laissez-faire. Fred James, what games? No legislation, their freedom to cramp. That's why the trader was a champ. In South Australia, the water is warm. Crayfish are eager to breed and to swarm. Active relationships readily form. That's why the crayfish won't have a ball. But in Tasmania, the water is cold. Crayfish aren't fertile until they're quite old. Till they're mature, they mustn't be sold. That's why the crayfish were too small. But when the law seized an interstate cray, Whitfield said nay. He prayed free trade. Then the High Court made a new judgment call. Free trade did not apply at all. Discrimination is now the sole test. Local protection implied or expressed. Outside those limits, the state knows what's best. That's why the crayfish is a champ. Once the new doctrine was fully unveiled, dozens of precedents suddenly failed. Dixon and Barwick no longer prevailed. That's why the crayfish is a champ. So we've returned to the framers' intent, seen what they meant. Gar's law, no more. Now 92 has the Mason Court stamp. That's why the crayfish is a champ. Holland Whitfield was one of the first spectacular results of the so-called Mason Court, but there were others, including Mabo and including the free speech cases. And as the remarkable decisions went on, the court came more and more under unprecedented political criticism from politicians in both parties. One of the last things I wrote while I was at Macquarie was a conference paper called The Unruly Child and the Dangers of Discipline. The use of the phrase the unruly child was a homage to Bruce Coper, who had used that phrase to sum up the history of the common law in Australia. The use of the phrase the dangers of discipline was adverting to the possibility, the threat, that politicians might seek to inhibit the High Court by making conservative appointments, or worse still, mediocre appointments, and alternatively to the fear that the court itself might be intimidated into withdrawing to a more conservative path. Now, I gave that conference paper before February 1996. It was published after February 1996. And what happened in February 1996 is that Michael David Kirby was appointed to the High Court. So in the published version, I repeated what I'd said about the danger of destructive appointments, but I said, it is gratifying that since this paper was delivered, any such apprehensions have been resoundingly dispelled by the appointment of Justice Michael Kirby, whose vigorous and erudite judgments as President of the New South Wales Court of Appeal since September 1984 had paralleled and sometimes outstripped the prevailing trends in the High Court. And it is one of many tributes that I've had to pay to Michael over the years. I want to finish tonight with one other song. We've referred to the troubles at Macquarie when I arrived here, and I knew something of what I was coming to, and I thought if I contributed a song, it might lighten the atmosphere. Once I arrived here, I quickly found that it was no laughing matter, and 7 years elapsed before I dared to sing my song. Finally, at a law school dinner, I thought that things had calmed down enough that I could dare to sing it. And the result was that both I and the university were sued for defamation. The alleged defamatory matter was contained in the second verse, so I'd better not sing that. But I think it might be safe to sing the first verse. We're at Macquarie, you won't be sorry when you see how great a law school we can can be. The Pierce Committee was none too pretty in its view, but they just never knew what we do. Our small group teaching succeeds in reaching all the class, and though we prove the law half-fast, we also prove it's a wondrous toy for all kinds of social ploy that makes Macquarie sheer pedagogic joy. The wave of managerial destruction that has wrecked Australian universities in recent years means that, unfortunately, the line about small group teaching is no longer true. But I think the rest of the song still is.